Asymmetrical Haircuts Justice Update with Janet Anderson and Stephanie van den Berg in partnership with justiceinfo.net.
Hi, Janet.
Hi, Steph. So, holidays are over. Here we are. There's been a huge amount going on, though, behind the scenes. And now we've got to catch up with it all.
Yeah, I did. I have to catch up a lot because I relaxed all summer and read about 6 books, which is, I don't want to brag, and I know Molly reads much more, but for me that was a big thing, and I read a lot of fiction, which was very lovely. If you want to find out about what we've been reading, me and Janet and Molly, you can go over to our Patreon page and see our recommendations.
And you can also sign up to our monthly newsletter there at no cost at all. But back to the main business, which is all these kind of justice and accountability stuffs, I thought that I'd start off with some of the Ukraine things that have been happening. So I caught up at one point with Craig Martin.
Yeah, he has a Jib Jab podcast, doesn't he?
Yeah, we've promoted that a little bit. It's a podcast that plays on the name of Jus in Bello, which is the laws of war as we know them, international humanitarian law, what's allowed and what's not, and Jus ad bellum, which is the laws of going to war, whether you're allowed to attack another country, and that's jib jab, as he said. So later on, you can hear Craig discussing Ukraine and Kursk. But first, I also spoke to Irina Marchuk, who's teaching in Copenhagen, a Ukrainian academic, about Ukraine signing up to the International Criminal Court. And she was so pleased that this was happening after all the efforts.
I would like to take this opportunity to congratulate all my colleagues, friends, and major stakeholders who've been working really hard over the last years.
Okay, before we get into what Irina has to say, Steph, what's the Stephopedia that listeners need to know as background?
Well, Ukraine has a long history with the ICC. We already had 2 referrals, one in 2014 following the Maidan uprising, and then after Russia annexed parts of Ukraine, Crimea, and then also tried stuff in the Donetsk and Luhansk regions in 2014. They had another referral which gave essentially the ICC jurisdiction to look into crimes under its mandate from 2013 onwards. And this is how the ICC has jurisdiction over Ukraine now. And it is important to note that the referral after the annexation already had a line in it saying that, quote, Russian commanders and DPR and LPR leaders. So that it gave the ICC jurisdiction over Russian commanders and leaders of the Donetsk and Luhansk People's Republic.
Yeah, and Ukraine, or at least Ukrainian politicians, because the referral was from the parliament, they kind of thought that they could shield the Ukrainian armed forces themselves.
Yes, and then in 2022, after the Russian invasion, the court opened an official investigation. That is now what's going on. And then last year we saw the arrest warrants for Putin and now also several other senior Russian leaders, which basically made it's a huge priority for the ICC. It's throwing resources at it. And it also kind of upped the ante in Ukraine for actually becoming an ICC member.
Yeah, amazingly, Ukraine isn't actually an ICC member, but now the parliament has agreed and the president signed, but there's still a bit more to go. So in my chat with Irina, which is quite long and quite detailed, and there's quite a lot of constitutional stuff in here, enjoy, I hope, but I think it's important, all the details. So I kicked off with whether she was surprised when she actually heard the news in August.
Well, I was surprised, as many others who were not in Ukraine, that it happened so quickly. As you know, the ratification bill was put forward to the parliament, I believe, on the 15th of August. And it was the 21st of August that the bill was ratified by the Ukrainian parliament. And I thought that the ratification bill would just be hanging on the parliamentary agenda for a number of years, the same that happened to the Bill 2689 that you might have heard of. It was a bill that was introduced earlier, harmonizing Ukrainian criminal legislation with the Rome Statute. And despite the fact that the bill went through all the parliamentary hearings, it was never signed into law by the president. So I felt that, we had a number of legislative initiatives before. They were moving slowly. Even if the parliament voted for the bill at the end, the president would not sign it into law. So I knew that this bill was different because it was put forward by the president. So impressive. I believe that the bill was passed with lightning speed. There is a lot of work which was done behind the scenes. Ukraine signed the Rome Statute in 2000, and it's taken 24 years for this to happen. So I do feel this is a huge achievement for Ukraine.
Well, that's what I wanted to ask you. Well, I mean, how did we get here? I mean, a lot of people, I think, would be surprised to hear that Ukraine isn't actually a member of the International Criminal Court because, I mean, it was way back that they made this kind of declaration to say, look into what's been going on, and they even did that twice. So why has it taken so long?
Well, first, Ukraine signed the Rome Statute in 2000. In 2001, the ratification of the Rome Statute was stalled by the ruling of the Constitutional Court of Ukraine that found the Rome Statute's principle of complementarity to be contrary to the Constitution of Ukraine. To put it in simple words, the fact that we did not see the word International Criminal Court in the Constitution of Ukraine was something that was seen as a barrier to ratification. The earlier version of Article 124 of the Constitution of Ukraine read that the administration of justice is an exclusive prerogative of Ukrainian courts. There were discussions afterwards whether the Constitutional Court of Ukraine was right, whether it understood correctly the principle of complementarity, but the barrier was there. So the only way to get rid of it was to amend the Constitution and to write in the International Criminal Court into the Constitution. And that happened in 2016. So it took 15 years for that to happen. However, it was a very strange way, the way the Constitution was amended as well. Because despite the fact that the amendment took place in 2016, it was mentioned that ratification of the Rome Statute of the International Criminal Court could only happen in 2019. And there were speculations why the constitutional amendment was adopted, but then the ratification of the Rome Statute was essentially postponed for 3 years. And, there are various theories, conspiracy theories around that. Of course, if we roll back in time a little bit, in 2014, Ukraine accepted the ad hoc jurisdiction of the ICC with respect to Maidan crimes. It was a temporary jurisdiction. Fast forward, Ukraine accepts yet another declaration under Article 12.3 of the Rome Statute with respect to alleged war crimes and crimes against humanity committed in Crimea and committed in Donbass. And so there was this misconception or myth that given that the fact is not a state party to the Rome Statute, Ukraine could recall the declaration, its two declarations at any time it wanted. And it was also somehow misunderstood that the ICC would not be able to go after Ukrainian armed forces. And that's why ratification was feared. There were a lot of myths and misconceptions. And I think that what's interesting, I participated in the event organized by Ukrainian Bar Association on the 21st of August, the same day that the bill was ratified. And it was mentioned that the work on ratification of the Rome Statute resumed in May this year, and the first step, which was undertaken by the presidential administration, was to talk to Ukrainian military. So there was a lot of communication work which was done, trying to persuade Ukrainian military that the ratification of the Rome Statute would not pose additional threats to members of Ukrainian armed forces. And prior to the vote in the parliament, it became clear, as it was announced by the Speaker of the Parliament, that the General Staff of Ukrainian Armed Forces supported the ratification bill.
Given all of that context of what was needed to kind of get this over the line, Ukraine has invoked this Article 124. I've seen a lot of criticism. We'll come to that later. But can you explain what you understand Article 124 might have been invoked by Ukraine for? You know, what does Ukraine see as the purpose of invoking Article 124?
Well, yeah, it's a really good question. And I struggle to understand it myself because my first reaction when I saw the ratification bill, I had hard times to understand why Ukraine decided to invoke Article 124. And those who are not lawyers, because I know that you're broadcasting to larger community, invoking Article 124 of the Rome Statute means that Ukraine will effectively shield its national from the ICC war crimes jurisdiction for the upcoming 7 years after the ratification of the Rome Statute. It's not a very smart strategic move for Ukraine.
But if you put yourself in the shoes of those in Ukraine who want to go ahead with this but want to make sure everybody is happy, is it specifically designed to say to the military, the same way as you say the way that the original acceptance of the ICC's jurisdiction, you know, way back 10 years ago went through, is it specifically designed to say to the military, don't worry, you'll be all right?
Absolutely. And what I understood from Ukrainian public officials, the representative of the presidential office of Ukraine, and also Ambassador Anton Koronevich, that Article 124 was not on the cards initially. It was later added specifically to dissuade fears that ratification of the Rome Statute would result in the prosecution of members of the Ukrainian armed forces. And this was the only way to convince the Ukrainian armed forces and other important stakeholders that the ratification bill should be put forward to the parliament. I believe that absent Article 124, there would not be overwhelming support in the parliament to pass the ratification bill. Also, a piece of valuable information that Ukraine did conduct consultations with the ICC registry about ratification and also about its invocation of Article 124. However, Ukrainian officials recognize that the ICC judges that have a final say on the way Article 124 will be interpreted, and it does not mean that the interpretation which was put forward by Ukraine will be accepted by the ICC judges. But, you know, as well, not much was said because these consultations were taking place behind closed doors.
I understand you're not an ICC judge, so you can't say yourself exactly how it's going to be interpreted, but what's your understanding as an international lawyer? Does invoking 124, the same way that France did at one point and Colombia did at one point, and it lasts only for 7 years, but you know, to what extent will it protect the Ukrainian military from any investigation by the ICC? Does it protect anybody? Does it protect them only on Ukrainian soil? Does it kind of go back and have some effect on the investigation so far? What's your understanding?
So first of all, my understanding that Article 124 declaration would not have retroactive effect. And I think this is something which has been discussed by many academics. The 7-year jurisdictional ban will only enter into force once Ukraine ratifies the Rome Statute, which is understandable. There were discussions taking place on the scope of Article 124, because it seems it's kind of awkward, but that you could shield your nationals from responsibility, and you want the ICC to prosecute your enemies, another party, because that does interfere with rule of law, as was put forward as well in an excellent post which was written by Tom Dannebaum on just security. And so the discussion is whether you can pick and choose. Okay, you protect your nationals, and you want nationals of enemy state to be prosecuted based on the principle of territoriality, whether this is something that is allowed by Article 124. Because as you mentioned, when France and Colombia invoked Article 124, they invoked it as a jurisdictional package. So basically, their declaration would have applied to any alleged crimes committed by their nationals and on their territory. And when we look at the literal wording of Article 124, it does say or nationals or territory. And I think this is something that was picked up by Ukraine, the literal wording. Whereas I do believe that when you invoke Article 124, it should be a jurisdictional package. It goes against the purpose, against the mandate of the International Criminal Court to allow only one party to be prosecuted while shielding another party from responsibility. Of course, all these questions were put forward to Ukrainian officials, and they did say that invoking Article 124 does not mean that Ukraine wants to give license to kill to its nationals. And they were saying that during the 7-year period, there will be important safeguards in place. So if members of Ukrainian armed forces are committing crimes, they will be prosecuted by Ukrainian courts. And as you know, by now, Ukrainian judiciary, despite all the skepticism, has proved to be quite functioning. More than 80 war crimes judgments have been delivered. And I do believe they have become better in terms of legal reasoning and also application of international law. So the comment by Ukrainian officials is sound in a way that Ukrainian judiciary is capable of dealing with alleged war crimes committed by its armed forces. And also Article 124 only relates to the ICC war crimes jurisdiction. So let's say if we imagine the situation that members of Ukrainian armed forces are committing crimes in the context of a widespread or systematic attack, their conduct could still qualify under crimes against humanity, which I think is unlikely, but it's important to understand that Article 124 is only shielding the ICC jurisdiction from prosecuting war crimes.
I want to put to you some of the criticism from Tom Dannenbaum's piece in Just Security. And I know that you're not a representative of the Ukrainian authorities, but just say how you react to this. Unprincipled, unnecessary, contradict Ukraine's national interest, anachronistic regression effects, uncertain effects, likely marginal, quite possibly counterproductive, and gives Putin and his anti-ICC agenda and the arguments about double standards in international law a big present. So how do you respond?
Well, I do agree with Tom on many points. I wish that the ratification bill would proceed without Article 124, and that's my position as well. I don't see the need for Ukraine to invoke Article 124 for the reason that the ICC is going after persons who bear the greatest responsibility for the crime within its jurisdiction. And although one may speculate that in every single armed conflict, crimes are being committed by all sides, I do think that when we look at the war in Ukraine, the majority of crimes are being committed by Russian military and also its affiliated militia forces. And if the ICC prosecutor had really wanted to issue arrest warrants against the members of Ukrainian armed forces, he would have done it by now. As well, there is a very important jurisdictional delimitation in the ICC. When we look at Article 8, the ICC would go after war crimes that are widespread and are committed as part of a larger plan. The ICC would not prosecute individual Ukrainian soldiers who might have mistreated a Russian prisoner of war, and it was a one-off instance. So I think that if Ukraine fully and unconditionally accepted the Rome Statute, there would be no risks whatsoever for members of Ukrainian armed forces, because I do not think that Ukrainian military is on radar of the ICC prosecutor at the moment. That's my understanding. But of course, I'm not having access to any confidential evidentiary files that are in the possession of the ICC prosecutor. So it's necessary to make this disclaimer. If you hear Ukrainian officials, they emphasize the positive aspects, the ratification of the Rome Statute itself. It's taken such a long time. And if this is the small price that Ukraine had to pay to invoke this Article 124, just to push forward with ratification, that was a fair price to pay. And it's as well emphasized that now the next step for Ukraine would be to focus on the implementing legislation. As well as, after the...
That's what I wanted to, Irina, that's what I wanted to ask you about, kind of what happens next. I'd seen that you'd written that there's going to be implementing legislation to actually bring the Ukrainian criminal code in conformity with the Rome Statute. What's that?
Well, as you know, the Ukrainian criminal code only to a limited extent criminalizes atrocity crimes. So we have badly written Article 438, which is a blanket norm and basically refers to violations of laws and customs of war that are provided in all international instruments that have been ratified by Ukraine. And it's been a challenge for Ukrainian prosecutors and judges to work with this vague provision. The Ukrainian Criminal Code does not have a separate provision on crimes against humanity.
How long will that take, do you think?
So I don't know. And I was quite surprised about the process myself, because for the first time I learned more about the process when I spoke to Ukrainian officials discussing further steps after the ratification went ahead. My understanding was that while all of us can relax and raise a glass of champagne to the fact that it finally happened. Or it looks that it will take a few more months because it's a package deal. As you know, there were quite few legislative attempts, as I also mentioned, on bringing the Ukrainian criminal legislation in conformity with the Rome Statute for various reasons. So this time, the drafters, the authors of this implementing legislation, they're less ambitious. Unfortunately, Article 438 violations of the laws and customs of war will remain intact. It will not be touched. Only the heading of the article will be changed from violations of the laws and customs of war to war crimes. And it was explained that the Ukrainian prosecution and the Ukrainian investigative authorities have worked with Article 438. There was so much work and time which were invested in trying to figure out how to use this provision in practice, that it would be very burdensome to include a full catalog of war crimes into the Ukrainian criminal code and start from the beginning and try as well maybe to explain how these two regimes would interact, like, how you are supposed to work with Article 438 before the implementing legislation came into force. So in order to avoid any troubles and to make the ratification process as smooth as possible, it was decided that Article 438 will remain under different heading. There will be a different provision that will be written in, and that's a provision on crimes against humanity that the Ukrainian Criminal Code does not have at the moment. The definition of the crime of aggression will be amended, and also common responsibility will be included as a form of liability to ensure that military commanders could also be held accountable. So this is a slimmed down version of Bill 2689. I believe the major provisions were taken from the failed legislative initiative, and they were inserted into the implementing legislation. So Irina Mudra, who is the representative of the Presidential Office of Ukraine, she said they're aiming to have the implementing legislation adopted in September. That's very ambitious. And if that were to happen and the implementing legislation will pass, that would finally become a law. So, there are still a few months for us to wait to see what's going to happen.
So we should expect Ukraine to turn up in The Hague at the end of the year for the Assembly of States Parties. I'm sure they would be there anyway, but with a full kind of delegation, their own seat, ready to vote on different things as a fully paid up member of the ICC.
Yeah, totally. I think that's the hope as well. It looks that the most difficult was to get the ratification bill to be passed. So I think it just, talking out the details with parliamentarians and getting the necessary support as well for the implemented legislation. So I do hope that Ukraine will be able to participate in the next SAP meeting as a fully fledged member of the ICC. I mean, that would be great. And I think that was also highlighted by Ukrainian public officials that Ukraine will get many benefits when they join the ICC. They will be able to fully participate in the SAP meetings. They will be able to participate in voting of the ICC judges, nominate their own judge. And also it was emphasized that Ukraine will have access to the trust fund for victims. Although I do think that argument was somewhat misleading, because we do know that the trust funds for victims is very underfunded. And in those situations where reparations were awarded to victims, they were either symbolic collective reparations or they were very insignificant individual reparations of, I believe in Katanga, we are talking about $250 or $300. I don't expect. But I think there was also this rationale that not only we have to appease the Ukrainian military, but we also have to address the victims. And we have to explain to the victims that they will have access to the reparations procedure in the ICC. Although I do think that more work will have to be done with the victims in the future.
I thought it was really interesting to hear what Irina had to say about Article 124 and how problematic or non-problematic it is. I had followed this news only kind of from the sidelines from my vacation in the Balkans, so I really hadn't cottoned on to Article 124, so I'm saved a lot of reading now about why it's probably problematic. I think it's one of those things that we're going to have to kind of see how it shakes out. There seems to be a lot of academic discussion about how this can be interpreted. Ukraine seems quite confident that it can be interpreted one way. I don't know. I really can't say. I can't look inside the ICC judge's head, but I think it will remain a point of contention and it will be litigated because, of course, if ever a Russian official comes to trial at the ICC, that would be the first thing that I would pick out as a defense counsel.
Yeah, and I think the other thing that I noted was how much complex work there still has to be put in on updating or changing or adapting in some way the criminal code of Ukraine. And we've touched that in a couple of other podcasts, but I think that that's something that we'll probably look at in some other podcasts again to see exactly how Ukraine is doing its own domestic prosecutions, because I think that will also come as part of any litigation at the ICC.
Yeah, and we had a lot about why it was unpractical for Ukraine to have kind of its own definition of war crimes. And what I understand from Irina is that this amended proposal, it would just keep that description but just change the name. So you have a kind of possibility of parallel proceedings, or some proceedings going under this law and other proceedings going under ICC terminology. I don't quite know. So that's one of those things we're going to have to see how that works on the ground.
Now, staying with Ukraine, but sort of changing direction, I know that all that stuff from Irina would usually be enough for one podcast, but I just had to go ahead and do another one, provide our listeners with a bit more of a service. So I decided to also have a look at the Ukraine incursion into Kursk, because it raised quite a lot of issues for me. So, Steph, again, in your Stephopedia role, what do you think that listeners really need to know?
A few weeks ago now, Ukraine, instead of kind of going all out for defense of Ukraine, decided to mount an offensive into Russia's Kursk region. So they are basically crossed the border and went into Russian territory to fight there. That is the hope, is that it takes pressure, or it leads Russian troops back to Russia to fight Ukrainians over there, so that there will be some alleviation on the Ukrainian front. I know, Janet, you always prompt me to do Stephopedia, and you say something about pictures of prisoners of war. But as I said, a limited internet access on the Balkans. I didn't watch.
Yeah, you didn't see that.
I didn't see any pictures of prisoners of war. So please enlighten me.
Well, I specifically saw some Russian soldiers blindfolded being led by Ukrainians to sit down next to a tree, being given a little kind of cushion kind of thing to sit down on.
Very fancy.
Who knows? But really that kind of sense of we are really abiding by the laws of war. And then there's also been reports of bombings that they've done, maybe of blowing up bridges and things. This is all via what Ukraine is telling the world. So I don't know enough about it, but it was all enough for me to start going whiz, whiz, whiz in my brain. And I thought that Craig Martin, who teaches at the Washburn School of Law in Topeka in Kansas, and I know that he'd started this kind of lockdown project of a podcast called Jib Jab, and I thought he'd be a really good place to go to for that quick and dirty, what's legal, what's illegal.
I'm going to break in, certainly, and it's not often that I correct you on pronunciation of English words, but I think it is Topeka, Kansas.
Well, thank you, because I looked at that and thought I have absolutely no idea. It's Kansas. I've never been there. Sorry to Topeka for mispronouncing you. As a typical journalist, of course, what I did to start with Craig is to just say, okay, Craig, can you boil this jus ad bellum, this state going to war, invading another state thing down to some absolutely key precepts, please?
In its simplest form, there is a prohibition on the use of force embedded in the United Nations Charter in Article 2(4) of the UN Charter, prohibits the use of force by states against the territorial integrity or political independence of other states or for any other purpose that is inconsistent with the principles of the UN Charter. And that prohibition is really the core of the jus ad bellum regime. And then there are some exceptions, right? The one being that states may use force if authorized by the UN Security Council under Article 42 of the UN Charter, or under Article 51 of the UN Charter, they may use force unilaterally in response to an armed attack, right? This is the exercise of the right of self-defense.
Then what about invading somebody else's country? Is that absolutely prohibited?
It is. So the invasion of the territory of another country is sort of the quintessential act of aggression, a use of force in violation of the prohibition on the use of force in Article 2(4) of the UN Charter, and would trigger the right of self-defense in Article 51. And Article 51 includes within it both a right of individual self-defense, which is the right of the country that's been invaded or has had a use of force against it, to respond with force in self-defense, while collective self-defense provides for the right of other states to assist that one state that has been attacked in a collective active or use of force to drive out the aggressor. So if we think back to the Gulf War of 1990-91, where countries, a coalition drove Iraq out of Kuwait, that was both an act of collective self-defense and was also authorized by the UN Security Council.
So looking at what's going on at the moment with Ukraine over in Russian territory in the area, the Oblast Kursk, is that legal or illegal?
You're referring to the Ukrainian incursion into Russian territory in the last few weeks. That would, of course, be part of the act of self-defense that Ukraine has been engaging in, right? The initial aggression here was the invasion of Ukraine by Russia, first in Crimea in 2014, and then more recently, the larger invasion. But that was an act of aggression. It was in violation of Article 2(4) of the UN Charter. And the Russians have, of course, provided a number of legal justifications for that use of force, none of which seem to have much merit. So the Russian invasion is the use of force in violation of Article 2(4), which triggers Ukraine's right of self-defense under Article 51. And then the right of self-defense is, of course, conditioned or limited by a principle of necessity and a principle of proportionality. And so really the only question in looking at the Ukrainian incursion into the Kursk region right now, which people have sort of characterized as an invasion of Russia, is whether it is proportionate. And that opens up a whole sort of messy set of analyses, which we can get into. But basically, the idea that is floating around in the ether and in the public discourse sometimes that the Ukraine is now sort of invading Russia and that this is somehow an act of aggression is simply not accurate. There is no, or the idea that Russia is now defending itself against an act of Ukrainian aggression. There's no self-defense to an act of self-defense. Adil Haq has a great blog post on this on Just Security several years ago, analyzing why this idea of self-defense and response to self-defense is just not a thing in international law. So really the only question in assessing the lawfulness of Ukraine's incursion into the Kursk region is it a proportionate act of self-defense? And I think the short answer to that is most certainly yes, for reasons we can get into if you want to unpack that.
Okay. Yeah. Well, you've invited the unpacking. Some of the things that people have been writing about and have started me wondering is when you get an attack on an oil refinery where it might be both military and civilian, and when you get some attacks on things like bridges, which might also be used by civilians as well as military. I mean, is that the kind of analysis that can be used to decide proportionality, whether it's civilian, military, or am I barking up the wrong tree there?
So I think somewhat.
You're very polite, Craig, with saying somewhat. Yeah, I'm just obviously barking up the wrong tree. Tell me.
Not really. For reasons I'll explain. It's a complicated issue. But just to sort of unpack first the issue of proportionality itself. And there's the reality is that while the principle of proportionality in international humanitarian law, jus in bello, is quite clearly defined in the additional protocols to the Geneva Convention, it's very hard to operationalize. It's very difficult to measure the things that are supposed to be proportionate to one another in IHL. But the definition itself is very clear. In jus ad bellum, there is no clear definition of what the principle of proportionality is, and there are disagreements about what you're actually measuring. Like proportionate to what is the big question. And there are two sort of competing ideas of what proportionality means in the jus ad bellum sense. One is that it's a tit for tat. So the use of force in self-defense has to be proportionate to the harm caused, the nature of the armed attack itself, which is sort of a quantitative measure and is often called the tit for tat conception of proportionality. The other is a teleological or a means ends conception, which I think is the more dominant one, at least in international law scholarship, which says that the use of force in self-defense has to be proportionate to the objectives, the purpose that is being used for, which is ultimately to stop, to terminate, to prevent the ongoing armed attack or acts of aggression. And so if we look again to the Ukrainian situation, given the nature of the Russian aggression, the extent to which, at least initially, the invasion of Ukraine looked like an existential threat, almost any response by Ukraine would be proportionate, regardless of whether you use the tit for tat or the means ends conception of proportionality. And certainly the incursion into Kursk, which has been explained by Ukrainians as having the purpose of trying to draw forces away from territories within Ukraine, certainly has a defensive purpose. It has the purpose of trying to prevent the ongoing armed attack, ongoing attacks by Russia, and would seem to be entirely proportionate with both the objective and certainly the magnitude of the invasion by Russia. To turn to the second part of your question, though, and whether things like striking oil refineries or civilian infrastructure or bridges, that is really subject to a different analysis, right? This is where the difference between jus ad bellum, which is the legal regime that governs the use of force, and jus in bello, or international humanitarian law, which governs the conduct of hostilities. And so whether Ukraine can strike an oil refinery really comes within the ambit of international humanitarian law. Is that a civilian objective, which the principles of IHL prohibit the deliberate striking of civilian objects, right? Unless you can show that it has become a military objective by its nature or use. And so that's a different analysis altogether, and really is distinct from the question of, is the use of force in the Kursk region proportionate within the context of the doctrine of self-defense?
What about kind of weaponry or support or anything else that Ukraine may be getting from any of its allies and then kind of using that on Russian territory? Is that just a matter of politics and whether sort of it's politically acceptable to Ukraine's allies, or are there legal implications there?
No, those are primarily political and policy considerations, right? I mean, the reason that NATO and the United States in particular have been very sensitive to Ukraine using long-range weapons within Russia by Ukraine is a concern that Russia will escalate and interpret and characterize those strikes by Ukraine as being on behalf of or somehow implicating NATO, and therefore escalate the war and draw NATO into the conflict. But from a pure legal perspective, if Ukraine uses a weapon from the United States to strike some target within Russia, the question is simply, well, was it proportionate or not? And under IHL, was it a legitimate strike against a military objective? And where the weapon came from is really neither here nor there.
So if you look at previous examples, you've already mentioned Gulf, but other places where there have been this kind of self-defense incursion by one country against another in response to aggression. Can you find other examples and say what Kursk is like and not like?
Sure. I mean, I think one example that comes to mind quite clearly is the 1973 Yom Kippur War, where Egypt and Syria launch a surprise attack against Israel. This is clearly a violation of Article 2.4, an act of aggression. Israel is the defending country. But nonetheless, Israel, in the course of that war, crosses the Suez Canal into Egypt and gets within 100 kilometers of Cairo, and similarly, goes into the Golan Heights and past the Golan Heights and into Syria, and I think gets to within 40 kilometers of the capital of Syria. So there you see Israeli forces, defending forces, exercising self-defense, making serious incursions into the territory of the aggressor states. And those incursions, in fact, do have the effect of altering the dynamic and are important factors in the conclusion of the conflict and the development of a peace treaty. And nobody questions whether that was legitimate as part of the act of self-defense by Israel. They were seen as proportionate. They were certainly for the purposes of self-defense. They were then returned with the conclusion of the conflict and the peace treaty, which, of course, can be contrasted with the 6-Day War, 67 War, in which Israel seizes territory. Now, there's a whole controversy over the extent to which the 67 War was a war of self-defense on Israel's part, whether Israel was the aggressor or the defending state. But even if you assume that Israel was the defending state in the 67 War, you would argue that, for example, the seizure of the Golan Heights from Syria was similar to what happens in the 73 War, but then, of course, they retain it. And it's the subsequent retention of that territory, the de facto annexation of the Golan Heights over a period of years, that becomes unlawful. But the initial seizure of the Golan Heights in that conflict, if you accept that Israel was the defending state, would arguably have been entirely legitimate.
Okay, I'm just going to react back off the end of that interview with Craig, because that was the answer that really got to me. I understand that under international law, this counterattack by Israel was legal, and therefore occupying these various parts of other countries was legal. But it just kind of stuck in my craw, because it felt to me like it was all started, therefore, to be quite dependent on what our norms are, what our arguments are around international law at any particular time. Back in 1973, things were seen in a particular way. Here we are in 2024, and I'm just not too sure if we would see things exactly the same way now. It feels still, which I know international lawyers will hate me saying, but it still feels to me that it depends who is arguing what, and whether you've been educated in the US or whether you've coming from some other part of the world, about what you think is right and what you think is wrong. And I know that's so journalistic of me, and it's so not a lawyer, but I did end that interview thinking, so bloody hell, everything can be argued.
What it reminds me a bit of is this discussion about self-determination that I know a lot about with Kosovo and Serbia. And that also has states kind of twisting themselves in all kinds of ways. And you have states that absolutely accept Kosovo's right to declare independence and recognize Kosovo as a country. A majority of the countries in the EU do, but for example, Spain doesn't, because it has its own separatist movement with the Basques. And if you take the Kosovo example, then that would essentially imply that you would allow the Basque country to call for independence. Now, Russia has always been a staunch supporter of Serbia in that Kosovo should be Serbian and stay Serbian. But now that it is trying this self-determination situation with Luhansk and the Donetsk region, it had to switch positions, which annoyed Serbia again, because then if you're saying that these republics should be able to call independence, then essentially you're recognizing that Kosovo could call independence. So it really depends on which side of the political spectrum and what your beliefs is, how you interpret that, and it shifts with the way that politics shifts. I think we like to think that law is not monolithic, but like very inchangeable, and that it's not kind of subject to fashion. But I think we've also seen that it is actually subject to fashion, and how you interpret things changes over time. And this is one of those things.
Yeah, exactly. I mean, I feel here I am in my undergraduate phase of trying to understand how the system works. But I'm a journalist. I have to explain it to others. And I find it difficult to say absolutist things at this point because, as you say, politically, states change their minds. So we're on again. Next week, we've actually got some other parts of the world lined up, so stay tuned.
Stay tuned, and thank you very much, Janet, for catching me up on everything that I missed on vacation.
This was Asymmetrical Haircuts, your international justice podcast, created and presented by Janet Anderson and Stephanie van den Berg. This episode was produced in partnership with justiceinfo.net, an independent site covering justice effort for mass violence. This episode was recorded at the Hague Humanity Hub, home to a community of innovators in the field of peace, justice development, and humanitarian action. Music is by audionautics.com, and you can find show notes and everything about the podcast on asymmetricalhaircuts.com. This show is available on every major podcast service, so please subscribe, give us a rating, and spread the word.